Tonight on Nation to Nation, the Anishinaabe Nation's Deputy Grand Chief weighs in on increased Indigenous police funding and getting Senator Lynn Bayek to resign.
Everything she's been talking about, the racism and the bigotry, is not good for our people. It's not good for the city of Dryden.
Plaintiffs in a current court case in Northern Ontario say $4 a year in treaty money isn't enough.
A retroactive payment for all of the years that the annuity was not increased.
The Supreme Court of Canada hears a case on Monday. Before laws are passed, First Nations must be consulted.
Lawmaking is such a critical and important strategic decision-making tool by the government that has the potential to adversely affect a broad number of First Nations in very significant ways.
This is Nation to Nation. Hello, I'm Todd Lamoran. Yesterday, Indigenous policing got a shot in the arm. Public Safety Minister Ralph Goodall announced $291 million over the next 5 years in funding. It comes after years of complaints that Aboriginal police forces are chronically underfunded. Anishinaabe Police Service is the largest in Canada. It serves 35 communities.
Its budget has been too thin and too short-term, subject to periodic renewals and extensions from time to time.
To talk more about it, I'm joined by Derek Fox. He's the Deputy Grand Chief of the Anishinaabe Nation. Welcome to Nation, Mr. Fox.
Yes, hi, Todd.
Yesterday, your Grand Chief, Alvin Fiddler, called this announcement huge. Why is that?
Well, he, as many might not know, he's responsible for police services at Anishinaabe Nation. When I say responsible, I mean he's got this portfolio, and when he means huge, is that it's an essential service. It's not just a program, and I think that many of our police officers are underfunded. Our programs are underfunded, and they don't have a lot of support in the north. As you know, many of our communities have one officer at the most when they should have at minimum 2 officers, and their safety is put into risk. Their safety is in jeopardy. So this is huge, and that's what he means by that.
What's the biggest difference band members will see over the next 5 years?
Well, that's going to depend on the leadership within the communities. That's going to depend on Anishinaabe Police Services and how they use this funding. But I imagine that they're going to use it to get more officers, as I spoke about, get more tools at their disposal, whether it's jail cells or vehicles or skidoos or so on. I imagine it's going to be up to the leadership within those communities to use this funding as they see fit for their communities. The thing with Anishinaabe Nation is that we have a large territory. We have very diverse communities. We have 49 communities, and they're all diverse. They're all unique in their own way. So we can't speak for how they're going to do it, but I imagine that's going to be an increase in officers and vehicles and so on will be how they do it.
How far does this funding announcement go to your long-term plan of having funding over more than 5 years?
It goes. It's a step in the right direction, and I share the Grand Chief's sentiments and his vision as his Deputy Grand Chief. We have a long-term vision that goes from anywhere from the coming year to the next 5 years, the next 10 years, and so on. And the bottom line is that we want to ensure that the safety of our people is put first, and our police services are extremely essential to the safety in the north, not just to our people, but to the police officers themselves. So this is a huge step towards ensuring that Anishinaabe Police Services is well established well into the future.
Now, Deputy Grand Chief Fox, I want to switch gears a little bit. Of course, very recently, you initiated a website to get Senator Lynn Bayek to resign. How How will the petitions on there, do you think, achieve that?
Well, I guess we'll wait to see how that plays out. But I think the main purpose is to create awareness and. With respect to the issue, I know that the Grand Chief himself and Grand Chief Kavanagh and Grand Council of Treaty 3, which is relevant because Dryden's in the Treaty 3 area, so it was important to ensure that Grand Chief Kavanagh was informed and included. I know that they came to this choice together. And the outcomes, I'm not sure what will happen. I'm hoping that the Senate makes the right choice, and I'm hoping that the people of Dryden, their city and council, can discuss this and come to a right decision when it comes to issues with this whole Bayak family. But for us, it's just to bring awareness to the fact that everything she's been talking about, the racism and the bigotry, is not good for our people. It's not good for the city of Dryden. It's not good for our people in the area. So I think it's important to ensure that everyone knows that there's no place in Canada for this. Sorry,
I've heard talk.
Okay.
I've heard talk that in Dryden that there's some people asking or advocating that there should be a boycott of Bayak businesses. Do you think it should go that far?
I believe it should go that far. You know, our businesses, our people use the winter roads often. Our winter roads go through both Sulikote and Red Lake near the Dryden Township, and a lot of our people use their businesses to either purchase vehicles and so on. And I think any means possible that we could spread that message to show what kind of influence our people have within the territory, we should take advantage of. And it's important to note that our little bands, which is a largest young First Nations hockey tournament in this region, Dryden is the host for that tournament, and that's going to be mid-February, early February. And they benefit a lot from this tournament, from hotels to restaurants to these businesses, which includes the Bayak businesses. So, you know, to have a member and a leader within that community casting racism towards the people that bring financial benefit to the community is just unexplainable. I just can't believe it.
Okay, I want to thank you, Deputy Grand Chief Fox, for talking to me. Thank you.
Thank you.
Time for a break, but coming up, we learn more about a court case. Its aim is to substantially increase the $4 a year in treaty money for some Ontario First Nations. On the prairies, it's a common sight during treaty days. People signing up and in return getting a crisp $5 bill, all under the watchful eye of an RCMP officer dressed in red serge. It's the annual annuity for their ancestors signing treaty with the Crown. Over the years, people have suggested the amount should have gone up. After all, what does $5 get you now? Well, a group of nearly 24 Anishinaabe First Nations is taking the government to court over just that issue. In 1850, they signed the Robinson-Huron Treaty. The annuity was $1 a year. However, the treaty had a provision that if revenues went up on the land, so would the annuity. And it did in 1874 to $4. Since then, nothing. So 3.5 years ago, the Anishinaabe around Lake Huron took the government to Ontario Superior Court. The ongoing hearings, which are being live streamed, are about halfway over. Join me now is Mike Ristoul. He's the chair of the Robinson-Huron Litigation Fund. Mr. Ristoul, welcome to Nation to Nation.
Thank you, Todd. It's nice to be with you.
Why did the annuity never go past $4?
The Crown appears to have the impression that there's a limitation on the annuity, that $4 is the maximum that is payable under the treaty. We took a different interpretation of it because the treaty says that the annuity would be increased and that the Crown would, actually the Queen at the time, it was written into the treaty that the Queen would consider increases to the annuity. So that's the basis of what we're taking to the courts today.
How did the current lawsuit, which just, I think it was filed about 3.5 years ago, how did that come about?
It took a long time, Todd, as a matter of fact. Over the years, the chiefs have made pleas to the Crown government officials and to politicians to have the annuity increased, and it kind of fell on deaf ears. So what happened then is when the chiefs got together, they said it's no sense going to these bureaucrats or the politicians. They're not going to do anything, so we should take this to court. We think that there's enough of a legal edge here for us to take this to court, to win it in court. So that's what they did. In about the early 1980s, the chiefs decided to take the case to the courts. We've been working on getting it together since that time. It took a long, long time for the chiefs to come together in unison, because there's 21 First Nations that you have to deal with. So 21 chiefs, 21 councils, and all of those communities. It took a long time for us to come together in unity to do that. But we finally did in 2010, and we filed the case in 2014.
I believe it's my understanding, too, that in 1982, when the Constitution was being repatriated, you made one last-ditch attempt to talk to the Queen about this.
That's right, yeah. There was a delegation of chiefs that went to England at the time, around that time, and their intention was to talk to the Queen about the treaty and about their obligation under the treaty. When they got to England, apparently, what I'm told is that they met with probably a bureaucrat over there, or a representative of the Queen, and said and listened to their to what they had to say, and then said, "Thank you very much. That's very interesting, and thank you for coming all this way to talk with us about it." And that was it. That's what they got from traveling over to England to see Queen Elizabeth.
So what are you seeking? Do you have a ballpark figure at this point?
What we're doing, we've hired an economic historian, and he's put together all of the facts that he could gather in his research of revenue in the territory of the Robinson-Huron Treaty. And what he's done is he's taken those amounts, and he's calculated based on other treaties that have been signed, such as those in Northwest Territories and in British Columbia. Some of those treaties, the percentage of payment to those First Nations out of the revenue are run from 7% to about 50%. So that's the basis of that calculation. We don't know exactly where it's going to end up at this point, because it's before the courts, and it's also subject to a round of negotiations at the current time.
Are you looking for a one-time settlement, or would you prefer an annuity like you had before?
What we would like to have accomplished here is a retroactive payment for all of the years that the annuity was not increased, and then on a go-forward basis, some sort of formula on a go-forward basis that will increase the annuity from time to time. This is what we're asking the Crown.
I imagine it'd be a lot more than $4, though.
I would hope so, yes.
How significant do you think this case is for Prairie First Nations whose citizens get $5 a year?
I think it's only fair that if the Crown makes a lot of revenue from the territories that have been ceded by First Nations, that they should share that revenue rather than the stated amounts that are in the treaties, because $5 per individual just doesn't seem to be fair for all of the land that those First Nations in the West have given up. So I think that those considerations have to be taken in those areas as well.
I imagine they're looking at this case quite closely as well.
Absolutely. And I've got a number of calls from some of those people from the First Nations out west, and they're very interested in the outcome of this trial.
You're, of course, hoping to win at a lower court level, but wouldn't this case have more far-reaching effects if it made it all the way to the Supreme Court of Canada?
I would hope that it would be settled here at the court level, at the lower court level for us, so that we can get on with life, rather than have to fight it all the way to the Supreme Court. And I think it's meaningful for us if the Crown does not appeal the lower court ruling, that it would be settled. For other people, perhaps they may have to take the case on themselves, their own case on, based on our lower court ruling, and take theirs on to the Supreme Court level to get theirs done.
Well,
as a lay person, that's the way I see it.
Mr. Ristoul, I'll certainly be watching this with great interest. Thank you for appearing on our show.
Thank you very much, Todd, for having me.
Time for a short break, but we'll be right back. Welcome back to Nation to Nation. You may have heard about something called the Haida Court decision. It established in 2004 the principle that the Crown has a duty to consult First Nations before developing on their traditional lands. This Monday, the Supreme Court of Canada will be hearing a case that is potentially just as important. The justices will hear arguments on whether the Crown has a duty to consult before it passes legislation that could affect Indigenous people. The case was brought forward by the Mikisew Cree Nation from northern Alberta. To talk more about the upcoming hearing, I'm joined by Carey Brooks. She's one of the Mikisew's lawyers. Welcome to Nation, Ms. Brooks.
Thank you. Thank you very much for having me.
So just how important is this case potentially going to have?
The case is extremely important. I think, as you just outlined, in 2004, the Supreme Court of Canada established that there was a standalone duty to consult in the Haida decision. And so the Crown has an obligation to consult whenever it's contemplating conduct that could adversely affect the rights of First Nations. This case addresses a question that's not yet been squarely addressed by the court, and that's whether that standalone duty applies when the government is considering laws and making laws that could adversely affect First Nations. So as you can imagine, lawmaking is such a critical and important strategic decision-making tool by the government that has the potential to adversely affect a broad number of First Nations in very significant ways. So the case and the court's decision on this issue will be extremely important to all Canadians.
What was the federal legislation that caused the Mikisew to go to court in the first place?
In 2012, folks might remember that under the Harper government, the government passed a number of laws that changed in quite a dramatic way the way that federal environmental protection would be carried out. And in fact, it was the act of the government in making those laws. It was changes to the Fisheries Act, to the Navigable Waters Protection Act, to the Species at Risk Act, and to the Canadian Environmental Assessment Act that caused and prompted the Idle No More movement. There was so much outrage by Indigenous nations across Canada that the federal government would make these kind of changes and really strip the federal government of its oversight role in these areas, or very limit it so severely that caused these protest movements at the time.
Critics say a victory could cause delays in enacting legislation or make it impossible for legislatures to be flexible when it comes to crafting legislation. How do you respond to some of those criticisms?
And you're exactly right that is one of the primary arguments that we see the Crown making in this case. They're in fact the very types of arguments that were advanced by the Crown in the Haida case, in the Mikisew case, which established a duty to consult with respect to treaty rights and the adverse infringement of or adverse effects on treaty rights. And we say that's just simply not the case. that in fact lawmaking processes are by their very nature quite lengthy. They build in all sorts of opportunities for consultation. There's all sorts of decisions that are made along the way before a bill even makes it into Parliament, and that these processes allow for consultation. But more than that, we say that, very recently the Supreme Court of Canada in a decision called Clyde River said that the Crown must consult. And so the Crown has to find a way to build in consultation into its processes. And it's simply no answer to say that that might lengthen the time for lawmaking processes. A reconciliation demands and requires that consultation be carried out.
You talked about processes. Of course, right now there is a process before federal legislation becomes law. It goes to committee, witnesses testify before a committee of MPs. There can be amendments in the Senate. Of course, there's debate in the House. Isn't that consultation? Couldn't that process be beefed up, I suppose, and that'd be consultation?
So there's a couple of problems with relying on the parliamentary process to discharge consultation. Of course, it's open to the Crown to use that process, but we have concerns about it. We would have concerns about being left to that late stage. Oftentimes there's a momentum like there is in project development as well, that the further down the process it gets, the more entrenched and committed the views are around that particular legislative proposal. So consultation, the law requires it happen at the earliest possible stage when there's an opportunity for input and meaningful input from the First Nation that can actually change. So the Crown can actually change its direction if it needs to. So there would be a concern about it waiting for that stage until that late stage. Of course, the Crown, if it does rely on that late stage, then the court could superintend, we say, its conduct at that stage. But the law does say it has to happen at the earliest opportunity when the Crown is first contemplating making the changes.
We've been talking about federal legislation and the process in that. Would this a court victory affect provincial legislation as well?
It absolutely would, yes.
This would only be laws right now, from what I read, that would affect treaty rights or Indigenous people directly. So we're not talking about laws that, I'll just throw out an example, immigration or foreign affairs. I'm assuming those would still not be touched by this?
Yeah, the laws that would be implicated, or the conduct that is implicated, is again going back to the very basic test of consultation. It arises because of the special obligation that the Crown has to our Indigenous nations and to advance reconciliation, and because the honor of the Crown requires this with Indigenous nations, that the laws that would be implicated are those that adversely or have the potential to adversely affect Indigenous interests and rights.
Okay. Well, we'll certainly be looking forward to what happens on Monday. Of course, it'll take about a year, I suppose, or a year to 18 months before we actually get a decision. I believe that's how long it takes, right?
Hopefully not that long, but it will probably take a number of months.
Okay. Well, thank you, Ms. Brooks, and thank you for doing this.
It's a pleasure. Thanks.
And if you missed any part of tonight's show, you can check out our podcasts. Go to aptnnews.ca/podcast. I'm Todd Lamoran. Have a great evening.